Trump Legal Cases Daily Digest, January 5, 2024. Happy weekend. The court schedule is becoming highly animated on the election interference and presidential immunity cases. The oral arguments are scheduled for January 9 in the D.C. Circuit Federal Appeals Court to decide whether Trump's federal election obstruction case should be dismissed due to presidential immunity. On Friday, the Supreme Court agreed to rule on the Colorado ballot case. Post-trial briefs were also submitted by New York AG, Letitia James, and the Trump co-defendants on Friday. The closing arguments are set for January 11 with Judge Arthur F. Engoron on this Trump civil law case. New York AG increases her request to $370 million from Trump and co-defendants. New York Attorney General Letitia James has called for a permanent ban on Donald Trump from New York's real estate industry, seeking a substantial penalty of $370 million as part of the ongoing civil case accusing the former president of engaging in outrageous fraud. Trump's legal team contends that the state's attempt to prohibit him from any and all business activities exceeds its authority, portraying it as a penalty far more substantial than the mere loss of money. In response, the Attorney General's office asserts that Trump's myriad deceptive schemes were so egregious that they defy innocent explanation. Despite Trump's dismissal of the case as a political witch hunt with no victims, the trial remains a significant legal hurdle for the former president. A frontrunner for the Republican nomination in the 2024 presidential election, Trump faces multiple legal challenges. His children, Donald Jr. and Eric Trump, testified during the trial, asserting minimal involvement in their father's financial statements. The recent denial of Trump's request to dismiss the case by Justice Arthur Engoron, who previously found Trump liable for fraudulent overstatements of wealth, suggests skepticism about the defense's arguments, describing Trump's claims as bogus statements at best and fraud at worst. Engoron's forthcoming decision after closing arguments will be crucial, potentially impacting the future of Trump's real estate empire. In their post-trial briefs filed on Friday, Trump's lawyers asserted, "There is no evidence in the record that the terms or pricing of any of the subject loans would have been different based on the purported misstatements alleged by plaintiff, emphasizing the lack of testimony supporting the alleged misstatements' impact on loan terms." They pointedly stated, "Not a single witness from any bank, or anywhere else, testified to this at trial." These arguments serve as a prelude to the upcoming closing arguments before Judge Arthur Engoron, with the potential for a ruling later this month. Despite Engoron rejecting key points of Trump's defense, including challenges to the statute of limitations and disgorgement, the legal battle persists, with the trial's focus on determining financial penalties and the future of Trump's New York business. Engoron's recent denial of Trump's attempt to dismiss the case signals his continued skepticism, underscoring the challenges faced by the former president in this civil fraud case. Trump's legal battles extend beyond this civil case, with criminal charges in 4 other cases. Engoron's verdict, coupled with ongoing legal challenges, adds complexity to Trump's legal calendar, raising questions about the potential consequences for his business and political aspirations. SCOTUS agrees to decide Trump ballot eligibility. The Supreme Court announced on Friday its decision to deliberate on whether Donald Trump should be disqualified from 2024 ballots due to his involvement in the January 6, 2021, Capitol insurrection. The case, prompted by Colorado and Maine disqualifying Trump under Section 3 of the 14th Amendment, revives this constitutional provision intended to bar those who have rebelled against the U.S. The court is tasked with determining if presidents fall under Section 3's disqualification, if states can use the 14th Amendment to remove candidates without congressional action, and if such removal infringes on the Republican Party's First Amendment rights. Trump contends that the Colorado court misjudged him, arguing that Section 3 doesn't apply to presidents due to their distinct oath and challenging the characterization of the Capitol attack as an insurrection. The legal battle emerged when Colorado's Supreme Court, citing the 14th Amendment, removed Trump from the primary ballot after finding him liable for inciting an insurrection. The Republican Party, intervening in the case, appealed to the Supreme Court, arguing the state court's ruling violated the party's First Amendment rights. Although the court agreed to hear arguments on February 8, the decision's timing raises questions about the impact on Trump's ballot eligibility. Despite this, Colorado Secretary of State Jenna Griswold confirmed that Trump's name will appear on the state's primary ballot in light of the Supreme Court's involvement, certifying the 2024 presidential primary ballot. Illinois voters aim to dump Trump from state's primary ballot. In Illinois, 5 voters have officially challenged Donald Trump's candidacy for the March 2024 primary election, filing an objection with the State Board of Elections on the first eligible day. Utilizing the 14th Amendment's insurrection clause, the voters argue that Trump's involvement in the Capitol attack disqualifies him under the constitutional provision. They contend that Trump falsely asserted his eligibility for the presidency, violating Section 3 of the 14th Amendment. The nonprofit group Free Speech for People, involved in drafting the objection, expressed readiness for such challenges, with its legal director, Ron Fine, stating, "We've been preparing for this since 2021. The ruling from the Michigan Supreme Court essentially stated that, based on state procedural law, they couldn't exclude him from the primary, Fine explained. Importantly, the Michigan Supreme Court did not make a determination on whether Trump breached the 14th Amendment. Despite this, Fine anticipates Trump's robust opposition to the objection filed by Illinois voters, echoing the former president's vigorous challenges in Colorado and Maine. Emphasizing Free Speech for People's stance, Fine asserted that Trump violated the insurrection clause in his presidential oath by inciting the events of January 6. He underscored the organization's commitment to upholding the Constitution rather than pursuing a political agenda, stating, "We're not pursuing a political project, we're enforcing the Constitution." While several states face 14th Amendment challenges to Trump's candidacy, only Colorado and Maine have officially removed him from their primary ballots. Trump, appealing both decisions, denied any role in an insurrection and criticized the Colorado Supreme Court's interpretation of the 14th Amendment. He argued against judicial intervention in barring him from the primary, emphasizing the potential historical significance of such a ruling. Despite setbacks in other states like California and Michigan, Free Speech for People remains optimistic about the Illinois case, highlighting that the Michigan Supreme Court's decision left room for new objections should Trump win the state's Republican primary. Despite SCOTUS appeal, Trump appears as candidate on Colorado GOP ballot. Despite the U.S. Supreme Court agreeing to hear an appeal by Donald Trump's legal team regarding the Colorado Supreme Court ruling that disqualified him under Section 3 of the 14th Amendment, he has been certified to appear on Colorado's Republican primary ballot. The Colorado Supreme Court had ruled Trump ineligible due to his alleged involvement in the January 6, 2021, insurrection. The former president's certification remains valid as the Colorado High Court placed a stay on its decision pending the U.S. Supreme Court appeal, allowing Trump to be reinstated on the GOP candidate list. Oral arguments for the appeal are set for Thursday, February 8, and unless the U.S. Supreme Court upholds the Colorado ruling, Trump will continue to be listed on the ballot. The certification deadline, January 5, allowed Secretary Jenna Griswold to finalize the candidates for each party's presidential primary ballot, giving county clerks permission to print ballots. While ballots cannot be altered once printed, Colorado has procedures for handling situations where a candidate is disqualified or drops out after ballots are sent. Griswold, with broad rulemaking authority, mentioned that she would not count votes for Trump if he were later ruled off the ballot after votes are cast. The procedures for such scenarios will be implemented based on guidance from the U.S. Supreme Court, depending on its decision regarding the appeal. Special counsel rejects Trump's contempt allegations in election interference case. Special counsel Jack Smith strongly rebuffed Donald Trump's claims that he should be held in contempt for alleged misconduct during the federal election interference case. Smith, defending against Trump's accusations of intentional violation of a court order, emphasized that such claims were false and baseless. Prosecutors highlighted the court's interest in a fair and prompt case resolution, expressing their commitment to comply with discovery obligations and pretrial deadlines voluntarily. They asserted that adhering to the schedule would position all parties for a seamless continuation when the case resumes. Nothing here requires any action by the defendant, and he fails to explain how the mere receipt of discovery materials that he is not obligated to review, or the early filing of government pleadings to which he does not yet need to respond, possibly burdens him, the special counsel wrote. Trump, who accused the special counsel of operating lawlessly, contended that the stay on the case prevented Smith from filing any documents. Trump sought an explanation from Smith, suggesting monetary sanctions or contempt charges. The ongoing dispute between Smith and Trump revolves around the trial's timing, with Trump alleging political motives for an expedited trial, while Smith refutes the claims, arguing that Trump aims to delay proceedings until after the November presidential election. Prosecutors vehemently rejected Trump's assertions that they used the stay for political propaganda, affirming their adherence to court orders and labeling Trump's allegations of partisanship and prosecutorial misconduct as groundless. The defendant claims that the government intentionally violated the court stay order and promoted a political agenda by fulfilling its continuing discovery obligations and voluntarily complying with otherwise suspended deadlines. That is false, Smith's team wrote. The government has not violated, and never intentionally would violate, an order of the court, and the defendant's recycled allegations of partisanship and prosecutorial misconduct remain baseless. The prosecutors emphasized that their filings required no response from Trump, ensuring compliance with the stay order. If you haven't already, be sure to catch our comprehensive analysis of the recent U.S. Supreme Court order regarding Trump's Colorado ballot disqualification. Check out the insights and details in our latest video on the channel. Thanks for watching. If you like it, comment and hit the like and share buttons. Subscribe for future videos.